Thank you.
Thank you, everybody. So you probably see me around. I'm the only one wearing a mask, so I'm easy to spot. I'm the person who does everything until I'm the last person doing it, and then for a bunch longer. I'm the last person who's still wearing a mask because I'm worried about COVID. I'm the last person with a VGA-only laptop because HDMI is too proprietary for me, so I refuse to carry an HDMI-based laptop, but I do have a converter that seems to work. And I'm also one of the last people in the world who still enforces the GPL. So it's kind of a theme with me. I want to start off by thanking, first of all, to thank Jeremy, the other conference chairs, and CERNET. This topic came up for me at our work in Software Freedom Conservancy in late March, and I was like, oh, sambaXP is probably soon. Like, maybe I could speak there. Of course, the CFP had closed and everything, but I emailed Jeremy and CERNET and everyone, and they were so kind to give me this slot to speak. It was just above and beyond because I missed the CFP and everything, so I really appreciate that. I also give a lot of talks about GPL to audiences that don't like copyleft that much. And I realized once I got here and started talking with everyone that I'd been away from this conference for way too long. The last time I was here was 2012, so that's more than 10 years ago. And it is wonderful to come to a community where the license that you all operate under is not constantly under question. Because if I go to a Linux event, about half the Linux developers love the GPL and the other half hate it. So there's like this disagreement even among the developers about their own license. So I just love coming to sambaXP because Samba developers made a very conscious choice about your license and you really care about it. And I just love to be in front of a friendly audience. Now, that doesn't mean you can't ask me lots of hard questions. Hard questions are great, but I know you're all very friendly to your own license and to the work we do at Conservancy. So it's really wonderful to be here. So in addition to being the last person that does things, I'm very fond of this quote of Donald Knuth's, which I've modified here. He's talking about email and why he doesn't read email anymore, which I kind of don't either. If you emailed me, you've noticed this. I read it once a week or something. But I really liked his point about this, of there are certain people who work in computing, and they really do have to be on the top of things. And that's, I see upstream work as really being on the top of things. For whatever reason, I've chose to build my career on the bottom of things. I wander around the dregs of the consumer electronics industry and find where GPL code is showing up and realize that basically none of it's in compliance with the GPL. And upstream projects, generally speaking, are sort of compliant by default. Everybody's operating in public, the source code's all available. But I rarely get to see source code. Kind of ironic for somebody who spent their entire career in open source, but I usually see binaries without source code, even though the source code is supposed to be there. So GPL enforcement has a relatively interesting history. I'm going to do this history in about 2 minutes, and I'm happy to talk later if people want to know more about the history if you're not familiar with it. But probably the most famous GPL enforcement historically that happened was done here in Germany by Harald Welte for about 10 years, 12 years. He was doing really active enforcement in the German courts, primarily over the NetFilter code base in Linux, and had a lot of success here in Germany with copyright-focused lawsuits. However, he's been way too busy. Every time I talk to Harald, he says, I want to get started doing GPL enforcement again, just as soon as I finish implementing the entire mobile stack as free software. And then he finished GSM, and then LTE came out, and he re-implemented LTE. So he's very busy doing very important work for the future of free software by re-implementing all the entire mobile stack as open source stuff. And his primary customer, by the way, this is totally fascinating, is cruise ships. Because when you get on a cruise ship, they apparently issue you a number that works throughout the cruise ship so that you can talk to everybody else on the cruise ship. So he's got a bunch of deployments, all open source on the cruise ships to make your mobile device work so you can talk to the people on the other side of the boat. But he's not doing enforcement for that reason. From 2001 to 2005, when I was at the Free Software Foundation, we were doing a lot of GPL enforcement. We did a lot of it in collaboration with Harald Welte. When I was there, for various reasons that are way beyond the scope of this talk, the FSF doesn't really do enforcement on its copyrights in GCC and so forth anymore, which is, again, a topic I'd be glad to talk about offline if you're curious why that is and what's going on there. So in 2006, the organization I work for, Software Freedom Conservancy, of which Samba is a member project, started doing GPL enforcement primarily for BusyBox. We did that in coordination with Eric Anderson, who was at that time the primary author of most of BusyBox. And we followed a number of lawsuits in the US over BusyBox violations. Now, at this point, unfortunately, as we hit 2023, SFC is the only organization really in the world left actively doing GPL enforcement for open source projects. There are companies that have what I call proprietary relicensing. Sometimes you hear it called dual licensing, which I think is a bit of a misnomer. Companies like MongoDB and these other ones where they hold all the copyrights and kind of trick you into buying a proprietary license if you make even the most minor mistake with compliance. So I'm not really counting them because they're really just proprietary software and GPL clothing. But as far as enforcing for community-based projects, we're kind of the only ones left doing it. And as we became the only ones left doing it around the early 2010s, we really made an effort to not file lawsuits. There was this other fellow named Patrick McCarty who was going around suing people to try to get money rather than compliance. He was kind of following Harold's model initially and then was really just after money for a while. He's been condemned by the rest of the NetFilter team for that behavior and so forth. But we saw that lawsuits were upsetting people, so we're like, well, let's just try for a decade to get compliance in the industry with the GPL without litigation, without going to any courts or any other administrative bodies. And I have to report, it was relatively unsuccessful. So in 2021, we filed a consumer rights-focused third-party beneficiary lawsuit in the United States against a company called Vizio. And I'm going to talk more about that and how it relates to traditional copyright-based GPL enforcement in a few minutes. So when we were doing that 10 years of no litigation, we were really focused on this idea of education. If we just educate everybody about what they're supposed to do with the GPL, everything will be fine, right? It's not a big deal. Giving people source code is a good thing. The license requires it. And this actually was extremely successful in business environments. So if you look at one business selling a product to another business, generally I haven't heard recently or very often in the past 10 years about violations where one large company violates the GPL when distributing to another large company. That's relatively rare that it happens because I think the incentives are kind of lined up. I'll talk about more about that in a minute. Now, for consumer-facing devices that you can go into an electronics store and buy today, almost all of them are Linux-based, and almost none of them are in compliance with the GPL. And ultimately, this has really changed my view about who the GPL is for and why it exists. Because early on, we had all this rhetoric about the GPL being for users to have freedom in their devices, to be able to do stuff. And the fact of the matter is, people who are upstream developers, while the GPL is a good license for you, and it's good for you, I would argue, it's not really for you primarily. And the reason why is that we've already seen in the world of open source that among developers, among people working professionally as software developers, they generally find that sharing their software has such benefits, across corporate boundaries and so forth, that we see lots and lots of open source projects developed in public, all the source code available under licenses that aren't the GPL. And you might ask, well, okay, then why do we need the GPL? Because people happily collaborate under the MIT license or the BSD license. It's not like everybody's making proprietary products out of every piece of non-copylefted code out there, at least in large software organizations. But the people that really benefit from the GPL are the end user, the person who buys a product and says, gee, I want to do something interesting with this product. I want to learn how to program with this product. I want to hack on it. And the reason why it matters most for them and not so much for the upstream developers is because this was a myth that I believed early in my career that is clearly not correct. It's extremely rare that you enforce the GPL and get some code that fits well into the upstream project in question. It just doesn't happen that often. That you find something that's good, because even if there's code that's new, it's usually not very good because it was added by somebody downstream who didn't understand the project well enough to even talk to the upstream in the first place, and they've probably done it wrong. So it might give you some ideas of what you could do, but it's not really going to be upstreamable code. There are some notable exceptions to this. If you want later the story of how basically exFAT is supported upstream in Linux because of a GPL enforcement action we did at Conservancy, that's a fun story. But that happened once last decade, where we got an enforcement action generated code that ended up upstream in a project. And this is simply because of that collaboration aspect. If somebody's really good enough to write upstream code, they're probably writing upstream code, or they're at least in the process of convincing their company to let them write upstream code. So you end up finding them all in the main project. You don't necessarily find that code downstream in the violation space. And meanwhile, the folks who make the consumer-facing devices, they have a very different goal than people doing business-to-business transactions. Because in business-to-business transactions, usually the customer is relatively savvy, right? It's a company and says, gee, we don't want to be screwed by our vendor, so we're going to make demands about our vendor. We're going to make sure that if there was something was GPL'd in there, we got the source code, in case we want to switch vendors, in case we decide we want to take it in-house, whatever it is. But when you're consumer-facing, most individuals who buy products don't know that they're Linux-based when they buy them. They don't know that they're supposed to get rights under the GPL. And meanwhile, the companies that make these products have various different vested interests of why they want to keep the product locked down. They don't want their users to be able to modify them. And there's a whole host of reasons they want to do this. The most common is that they believe they have some sort of better value than their competitors, and if they make their stuff locked down and proprietary, you'll be locked into them as a vendor. And also, this is a really disturbing part, they actually want products to end of life more quickly than they really need to. They would rather you end of life your mobile phone, your wireless router, and buy a new one than just keep updating the software on it with Lineage OS or OpenWRT and using the same device with newer software. They want to be in control of when they EOL the software means the hardware is also EOL'd. So they have that and many other reasons they want to do that. And unless we bring forward serious consequences for these consumer-facing vendors to comply with GPL, or if they fail to comply with GPL, bring them real consequences, there's really no incentive in there for them to do it. Because there's not a real push from the consumer base. We're slowly trying to build one, but at the moment there isn't much of one. We kind of are that in our Vizio case. So I kind of model GPL now as more of a gift that you as upstream developers are giving to consumers, or giving to your users. Because you're finding the next generation of computer geeks. I'm sure probably everybody in this room, we're all old enough to remember we got a device and we hacked on it, right? We took it apart. We figured out how it worked. We recompiled Linux when we first started using Linux. All of these things that we did in our generation, or my generation anyway, I'm older, I suppose, but younger folks, when they get devices, they get these Linux-based devices and they don't have the opportunity to rebuild the software and try out changes, try out different firmwares, see how it works. We're raising an entire generation of consumers who are not interested in repairing and modifying their electronics devices. And what's even worse is those that do this work, like the OpenWRT project, they're in this weird situation where they get a Linux device and they have to reverse engineer it even though it's Linux to figure out how it works. Now, over on the Samba side, you've had kind of a different space than the Linux side. And correct me if I'm wrong on any of this. This is what I'm seeing, but you all are operating this space more often. When we first took over the enforcement on behalf of the Samba community, the Samba team, it was used to, Simo Source of the Samba team used to do it, and he handed it off to us organizationally. There were some large storage vendors violating. Haven't heard of one for a long time. And I think those places' education efforts really worked because there was a real interest in those large storage vendors to be involved in upstream. Many of you work for them. And I think if you have a bunch of self-interested large companies, they actually see the GPL as a mitigating factor between them. Competitors see the GPL as, okay, well, if we both comply with the GPL, it's kind of a non-aggression pact. The license is there, we'll do the right thing. So we just didn't see a lot of the large vendors doing anything wrong. If there was a mistake, it was an education mistake. It was, oh, you were supposed to do this and you did that. Can you fix it? Very easy. You know, Jeremy, I've done this all the time. Just talk to them and they fix it. There was, for a while, a lot of violations that I found in like the 2014-ish, 2016-ish timeframe of these kind of mid-range NAS devices. These are the kind of things you can go and buy. They're like $200 US that you kind of put in your home office to host files. I think that market's basically gone. There's very few of those products still in the market. And I think there's a couple of reasons for that. One is that cloud storage is available. You can get a lot of space for free, and if you pay a small amount of money, you can get, pay some cloud vendor to give you Google Drive or whatever your vendor of choice is to get lots of storage space. So, and most internet connections are faster, so there is not that need for that mid-range NAS device. The other thing that's happened, and this is really where I'm seeing the problem now, is because USB drives are so large now, and wireless routers now have USB ports on them, it's extremely common in the Linux-based wireless router market, which are already violating the license of Linux in the first place, to now have Samba on them to make a little wireless router plus home file server, because you plug in a 2 terabyte USB drive and you've got 2 terabytes of storage for all your Windows boxes in your home. And most of the higher end wireless routers, and the higher end wireless router market's only the 120 euro, down to 80 euro devices, they all have these USB slots on them. They all are running Samba these days. And they're not in compliance with the GPL, as it turns out. And they weren't in compliance with the GPL before they put Samba there because they were already violating on Linux. Another one of our member projects at Conservancy is OpenWRT. And I'm relatively proud of this historical fact as GPL enforcement. So I led the enforcement effort, and Howard Velta was part of the coalition. It was a whole bunch of Eric Anderson of the BusyBox project, who I later worked with more on enforcement. We were all part of this coalition to enforce against Linksys on the WRT54G. And if you go back to the very original first, it was SVN in those days, check-in to the OpenWRT project, it was the source release that we were able to get Linksys to release. OpenWRT project was founded out of GPL enforcement against Linksys, which I'm very proud of. The downside is, we talk a lot with OpenWRT because they're a member project of ours, and they're telling us, well, nobody's really in compliance in the wireless industry. The source code is either not there or it's incomplete. So what we have to do is reverse engineer each new wireless router that comes out, even though it's running Linux. It helps that we know it's running Linux. It's a little easier to reverse engineer. And then only then can we get a build of OpenWRT working on it, because the source code they gave us isn't that good. So they would really, really like us to bring the entire wireless router market into compliance, which we haven't been able to do despite decades of trying. It's always a whack-a-mole thing where you go after a few of them, they come into compliance, and then you look away for 6 months and the next generation's out of compliance. That's exactly what happened with Linksys back in 2003. So I'm here to ask you, and I went to the Wine Project conference and asked them the same thing back in October, that Samba not let the BusyBox project and the Linux developers, which is not all of them, it's a subset of Linux developers who want to enforce the GPL, stand alone in trying to do these enforcement actions, especially now that Samba is showing up in these end-user devices that anybody who can get into an electronics store can buy one of these things for their home wireless router and have Samba in it. We need more projects who are in these devices to stand together and say, we all want these companies to comply with the GPL and do the right thing. And the OpenWRT project would really, really like the help, because they don't like it that they can't keep the wireless market in compliance. They want to port OpenWRT to every hardware platform that comes out, and results are often mixed, depending on who the vendor is and depending on how much they lock down the device in violation of the GPL. So there's a lot of, dare I say, the corporate word synergy here between various projects that are in Conservancy, BusyBox and OpenWRT, and the GPL compliance project for Linux developers in Samba, for us to really work together on enforcement. Now, early on, I promised to explain the Vizio case and how it relates. Historically, if you look back at how GPL enforcement's been done since the 1990s, it was always copyright focused. And you've probably even heard me say at some point the horrible sentence that I now know is wrong, that the GPL is a copyright license, not a contract. It's actually both. And we, just to be very frank, at Conservancy got some really bad legal advice that told us it was not also a contract. The GPL functions simultaneously as a copyright license and a contract. At the same time, it has all the powers of being a copyright license and all the powers of being a contract. And in the Vizio case, what we've done is we've gone to the store and bought these Vizio televisions, Software Freedom Conservancy. We tried to build an alternative firmware for them, but we couldn't because there was no source code in violation of the GPL. So we are in court now in the United States arguing that we are a third-party beneficiary of the GPL. A bunch of copyright holders chose that license. They intended us to get the source code. Vizio failed to do what the license said with regard to provision of source code. Therefore, we have a right to, as a third party who's a beneficiary of the contract of the GPL, to take action. I am thrilled about this approach. This approach was 3 years of conference calls with lawyers and trying to think through how to do GPL enforcement in a new way. And we're very excited about the approach. We expect it to succeed. We very much do. But it's also the case that it would be arrogant to believe that we're guaranteed success. Success is never guaranteed in anything you do in life. And it's certainly not quickly won if you have to do it through the courts. And I am still reeling from the decades I spent being convinced of the false notion that there was only one way to enforce the GPL. It was copyright or nothing else. So having been through that already, I think it'd be foolish to repeat the mistake of saying, well, now we have this theory we're working on called the third-party beneficiary theory, and we're only going to do enforcement that way. We're pretty convinced at SFC that we should be pursuing copyright-based approaches of enforcement of the GPL and non-copyright-based at the same time. It's just good idea to chase all the possible methods to get software rights for users that we can at our disposal. So we're going to have to get prepared for more copyright action, and I'm here to talk to you about it for Samba. And I'm going to leave a lot of time at the end because I'm sure you're going to have lots of questions about what I'm about to say. So let me say it, and then we'll go right to questions. And there's this politician in the United States called John Kerry. He ran for president once upon a time. And he had this phrase where he was terribly lambasted for this. He said, well, I voted for it before I voted against it, saying he had changed his position. And people are kind of obsessed with this idea when politicians, it's called a flip-flop in the US. I just read on Wikipedia this morning that in some places that speak English call it a U-turn. Some people call it a political backflip. But it's true. On the issue of asking people to sign copyright, I was for it before I was against it, before I was for it. So I have flip-flopped twice, I suppose you could say. But the fact of the matter is that I think that collection and aggregation of copyright into a single organization is a better strategy than trying, what we tried in the BusyBox case is we tried to kind of get everybody as plaintiffs in the lawsuit. So you'll notice the BusyBox lawsuits had multiple plaintiffs because we got Eric Anderson plus us, plus somebody else sometimes, that sort of thing. And I actually think it's better to aggregate copyrights. Now, I've been studying this issue. I'm not a lawyer, but I spend way too much time talking to lawyers. And my whole career, I've been trying to figure out, like, how do we get GPL enforcement done without copyright assignment? Because everybody knows the FSF copyright assignment process. It's a pain. No one likes to deal with it. And the FSF was always saying, you have to assign copyrights to us. It's so important. And now it's rather ironic that they're not doing enforcement anymore with all those copyrights they collected. But I wanted to find a way that we could enforce easily without collecting copyright assignments from people. And after 25 years, I basically say the best method to do at least the copyright side of GPL enforcement is to aggregate at least a large portion of copyrights in one place. It doesn't have to be all of it, but something substantial that can't easily be rewritten and thrown out of the project. aggregated into a nonprofit so you don't have like the MongoDBs of the world who are collecting the copyrights mainly to shake their competitors down and shake down their own customers half the time. But put it into a charitable nonprofit that's dedicated to enforcement. And that's, I think, the way to pursue copyright. So I've already said you all gave a wonderful gift to your user base by choosing the GPL. When you write your copyrights every day, when you commit to the Samba code bases, you're licensing your copyrights under GPL. It's a beautiful gift that you're giving, and I hate to come after receiving a gift to say, now give me another gift, but I need to ask for one more gift. I would really appreciate it and would make our work go much better if some of you would be willing to at least sign some of your copyrights to SFC for us to pursue enforcement actions, particularly in this wireless router market where we're having such a big problem now. The reason I can even make this request is because you all, there's so many great things about the decisions you all made early in your project. And this is one of the most amazing ones, because when I compare it to Linux, you're all in such a better state. Because really early on, I know there was an incident. Jeremy tells the story better than I do, so ask him if you want to know what the incident was. But there was an incident early in Samba's history that made those of you who were around at the time decide, wait a second, companies owning copyrights, or at least too many of the copyrights, could be problematic for our project. And it was really fortuitous that you all made the decision, hey, we want the individuals to have the copyrights. We want this project to be under the control of the individual developers, not the companies who employ them. And you're the only project in the entire copylefted world of software projects who carefully and methodically made that decision. And I know it's been backed off at this point a little bit, and you do have some corporate copyright, but it lives on that many of the copyrights in there are still held by individuals. And the power that you exercise by telling your companies, you've got to let us keep the copyrights if you want your code upstreamed. Thank you for doing that. And that's made me able to make this request. So, I mean, maybe it's a careful what you wish for kind of thing, because here I am these many years later saying, you all have individual copyrights. Now you can assign the Conservancy. But I really am appreciative that you all were able to do that, because in the Linux world, we have a problem, because most of Linux now, in current versions, are held by a group of companies, all of whom, frankly, are not so happy that Linux is under the GPL and wish that it weren't. So getting them to care about the GPL violations is basically impossible, and there are very few individuals left who have insisted in Linux to hold their own copyrights. It's funny to me because many of them have all given their copyrights over to their companies, and they come to me and say, well, copyright assignment's a horrible thing. I'm like, you assign your copyright every day to your company. What's the difference? But anyway, you all did a great job in the Samba community, and so I realize I'm making a big ask of you with that great job that you did to now help us do what we're doing, but I think it's a thing that is good for the community and we can work together on that would be good. We did solve the problem that the FSAF has with all the paperwork. We worked with the lawyers. There is a copyright assignment form on Conservancy's website. You can go to this URL, and thank you to Facebook, I guess, for making click-through agreements at what everybody has to agree. But there is a click-through agreement to assign your copyright to us if you want to do it quickly. It's completely self-service. You can type in a URL of a code repository. You can say, I want to assign all my copyrights. I want to assign only up to this date. And you can assign your copyrights at any time you want to us. We can also do more finely defined subsets. Folks have asked me about well, if I really want to pick the copyrights I want to assign, we can do things like get a list of commit IDs. We got to do that not through the form, but we can do that with you and say, okay, these commit IDs are the ones you're assigning from the Git repository. And just remember, the form says this and it explains this, but I just want to draw specific attention to it. You cannot sign, unless you're at a high-ranking level at your company, you don't have permission to sign your company's copyright stuff. It has to be stuff you know you own personally. But in the Samba community, a lot of you have already negotiated that with your companies because the Samba project for a long time required you to do that. So you're much more familiar with this than most developers would be outside of the Samba project. Just to give you a couple of things about how we do enforcement, if you're not familiar with how Conservancy does enforcement, a number of years ago when Patrick McCarty was making the trouble that he was, we published this list of principles of community-oriented GPL enforcement just to make sure everybody understood that the goal of GPL enforcement is not to make money, it is to get compliance with the license, it is to benefit the users. And so that's on the website of Conservancy if you want to read the principles that we follow when we do enforcement. There's plenty of blog posts that I and my colleague Denver have written all over our website. If you just choose the compliance tag or the copyleft tag in our blog, there's plenty of stuff we've written. Many of you are already on this mailing list. Many in the room are already on this mailing list. There's this private mailing list of people involved in the Samba project who enforce the GPL with us. And so we consult that mailing list, that private mailing list regularly when there's enforcement actions to come up. You all were on it, saw an email from me last week that I was coming here. But I want to end there and leave the last 15 minutes just for Q&A, yell at me, whatever you want to do. But thank you for listening to me, and thanks for taking my request seriously. Even if you decide not to, I appreciate your listening. Thank you. Oh, Jeremy's got his hand up first, of course. You need a mic, I think. The mic, can somebody run him that mic? Thanks, Volker.
People bring it to me. Thanks. So, Bradley, it's very ironic that you mentioned that early issue about why we decided on personal copyright, because the reason that Tridge and I made that decision at the time and forced the company to backtrack and give us personal copyright was that we didn't want to enforce. That was,
you did,
that,
you didn't, right? It was,
well,
we
wanted
certain types of enforcement, not other types of enforcement.
We wanted the control to lay in the hands of the developers to decide how and when to enforce. And what that allowed us to do was to take the right away from a company who wanted to enforce basically to attack a competitor,
right?
And it allowed Tridge and I to go to the violator and essentially negotiate a much more reasonable settlement.
Right.
And they did indeed come into compliance, et cetera, et cetera. So that's, what you're asking us to do is to give up our control of when we enforce, which I'm not so keen on. What was the other question I have, because as you know, Samba, the user space daemon, is essentially under an existential threat by the same companies that are donating the Linux kernel that essentially KSMBD will replace us. And my guess is that this will happen sometime in the next 10, possibly 15 years, maybe earlier, depending on how much resource they put into that. And so at least for the wireless router manufacturers who don't care about security anyway, because otherwise why would they be putting things in there? Essentially, it's utterly trivial for them to say, oh, Samba's being difficult? Right, well, let's flip a switch, and we're now KSMBD based. And, you know, I'm not saying we gain anything by being on those devices, but we lose. So we gain nothing by basically being difficult, and what we lose is the reputation with our vendors who are in the higher end. We become a project that litigates, and that scares me.
Okay, so
that makes things. That scares the corporate lawyers that I deal with.
I understand.
They don't want to deal with people who are difficult. And one of the things that I remember someone coming here to the Samba conference from a very large vendor some time ago and said, wow, you people amaze me. You have this reputation as being, you know, sort of GPL zealots, and you're the most reasonable people I've ever met. And I want us to keep that.
Yeah, and I do too. So let's chase your first question first. So I agree with you that copyrights held by for-profit companies have this danger because they have a for-profit interest. I'll point out that Freedom Conservancy is a charity, and we have a mission to advance open source, and we have various committed principles that we follow in doing enforcement that companies do not. So I think it's a qualitatively different thing to assign to a charitable nonprofit versus a company. That said, the other option, there's really only two options to do enforcement. One is assign your copyright to somebody and have them do it on your behalf. Two is come be a co-plaintiff with us, which the reason I didn't pitch that in the main talk was because I suspect no one wants the time commitment, make the time commitment of being a plaintiff, nor have their name on the masthead. Because if you assign copyright to us, you can always say, to kind of get to your second question, look, I assigned to them, you know, they're doing what they're doing. I may agree with parts of it, may not agree with parts of it, and leaves you with the full like range of answers.
But it leaves me with no control.
Well, I mean, we're obviously going to be closely involved with anybody who signs copyrights, and while on paper you have very little control, I think you'll have lots of commitments for us. And if you want a written commitment from Conservancy as part of the copyright assignment process, I'm totally willing to draft that with you and say, okay, what's the written commitment to the assignor need to be for folks in the Samba community to feel good about it? We could totally draft that up together. I don't know if that would help, Jeremy, but you're never going to sign your copyrights, I know. But and the other part of it is signing part of them is a pretty good compromise, I think, to some extent, because then you're not giving all the authority over, you're giving enough of it so that we can chase these things. Now, finally, to the vendor question you're sort of raising, it's not clear to me, and we should talk about it offline, because I don't want to start naming companies that are violating up on a recorded video, but privately, I'd be glad to talk about everybody kind of what companies we're seeing and sort of where they interact with the larger vendors, which you're much more concerned about. I have a feeling that I'm biased because I want this to happen, right? But it seems to me the larger vendors are just not going to care about these smaller time wireless router vendors who don't make big hardware.
Yeah, my comment is their lawyers will.
Yeah, I hear you. But
They will.
And then finally, on the Linux point and the KSMBD point, we've already got lots of assignments from Linux that we're pursuing and enforcing on Linux anyway. So in the end, even if they switch to KSMBD, we'll still be enforcing on Linux.
Yeah, so you're enforcing on Linux, Samba, and BusyBox. So the violating vendors go, okay, we'll replace BusyBox with Toybox, we'll kick Samba out. Now we only have one problem, which is Linux. Yeah. And we have KSMBD in that, and they have to have Linux. They can't get away from Linux, right? So, they can and will reduce their problems by removing the projects.
They will and they won't, right? Because they're still going to be enforced against anyway. And then there's the whole, this is a parallel effort to the third-party beneficiary,
yes,
and assuming we're successful, which I think we will be, it means anybody can sue them. They're really scared of the Vizio case.
Sure, if the Vizio case wins, you don't need us.
Yeah. Well, no, I think we need to, back to my point, we need to pursue both, right? But we need to use every tool in the toolbox because the problem is so bad.
But kicking us and BusyBox out takes you from 3 problems to 1. I know what corporate lawyers
would rather have. But they're the same problem. And in fact, there are problems worse with GPL v2, by the way. It's harder to comply with GPL v2 than v3, as it turns out, because of the termination clause. But on the BusyBox side, this is exactly the same point BusyBox brought to us. They were worried about being replaced, and there were a bunch of replacements started. There's Toybox, there's Toolbox floating around out there. BusyBox, within 5 years of the BusyBox lawsuit, BusyBox was back in every product. Every product not every product, but 90% of the products we see have BusyBox there. Actually, most of them have Bash there because BusyBox doesn't have enough of a shell for them. And they're putting Bash in there again, right? They're putting GPL v3 versions of Bash, even despite all this anti-GPL v3 rhetoric you hear from the corporate lawyers. All that code is still in there. They don't want to give it up. And it would have to be truly feature for feature compatible. And if they could have used KSMBD, why didn't they in the first place at this point? Because it's not there yet, I guess.
I thought you were going to speak to that point.
Okay.
I mean, what's the release cycle of these guys? And I mean, it will happen in the next whatever couple of years that they will replace us. Just for first the license issue and then memory footprint. And so, yeah, you have the memory footprint of the kernel anyway, and we, by our design, have a larger memory footprint. And we're talking like 8 megabytes, maybe 16 megabytes of RAM budget. So, and yeah, that's where you go.
But those all sound like technical reasons that Samba might not end up in wireless routers in the long term. I'd be surprised if the licensing reason would be the primary reason if there's all these other technical reasons.
I've talked to a large German vendor. The licensing reason killed us.
But that was probably V2 versus V3, right?
Yes. Yeah. Yes. I have one question. I mean, why do you need us? You have Linux, you have BusyBox. Why do you need us? Does it increase your chances to win this case?
We should talk about it. I think it would be very beneficial. I don't want to get into too much detail on the mic and on recording, but it would make a difference and it would be helpful. If for no other reason, the thing I'll say publicly is most people who work on Linux in particular are terrified of enforcing the GPL because they're basically constantly intimidated. They're told they're not going to get hired. They're told all sorts of things like that if they get involved in GPL enforcement. We have people who have anonymously assigned us rights because they're terrified that they'll never work again if someone finds out. So it's one of these things like when you form a union, right? If one person gets into an argument with their employer, they're probably going to get fired. But if a large group of people say, we all want this to happen because we care, it has a lot more power, and each individual is less vulnerable the more that are involved. And I think that's true for individual people, and it's also true for projects. More projects involved is stronger.
Tom.
I have a bit of a curiosity question that I didn't see on the assignment webpage. What happens if Freedom Conservancy goes under, disappears, reorganizes, things like that? Where do the rights go?
The rights, so the interesting thing about being a 501c3 charity is the rights can't they can't be bought, right? So nobody would be able to buy them. They would, as our assignment form is, I'd have to check I'm not a lawyer, and this is not legal advice. I'd have to check with our lawyers what happens if we cease operations. And that might be a bug report for the copyright assignment form. Maybe we should put something in there for ceasing operations, which is really all a C3 can do. We could cease operations and then the assets would just be in limbo nowhere.
Yeah, the rights are still assigned, but there's no...
there's no one to pick them up. Only another C3 charity with a similar mission could have them transferred, right?
And the rights are fairly specific about, they'll be handled under an free and open source license. It's a little bit vague, but it's just unclear of where the road leads, in the case of that kind of event.
I mean, I hope we won't go under.
I hope so too.
And we can't sell them because we're a C3, so that solves that part of it.
Interesting.
But yeah, I'll talk to our attorneys about what can we put in the form for the issue of what if we cease operations, because it's a good question. And I don't have a direct answer for you at the moment, sorry.